Thank you. I'd like to call this meeting of the Lancaster County Board of Zoning Appeals to order. And if the secretary would please call the roll.
Chairman Deese.
Here.
Gary Alden.
Yep.
Mark Boland. James Falkenberry. Here. Aaron Fender.
Here.
And thank you. We do have a quorum, so the meeting will continue as scheduled. The Board of Zoning Appeals has been kind of quiet lately, but we hope to speed back up. And I want to thank everybody for being here. Staff, thank you for the work you do. And gentlemen, we appreciate your volunteering and being in the meetings. The next item is the approval of the agenda. Gentlemen, you have before you a copy of the agenda. Do I hear a motion?
Make a motion to approve.
Have a motion to approve. Second. And a second from Mr. Alden. All in favor? Aye. Thank you. The vote is 4-0 to approve the agenda. You now have copies before you of the minutes for the March 4, 2025 meeting. Are there any changes, deletions, additions that need to be made to those prior to approval? Hearing none, do I hear a motion to approve as written?
Motion to approve.
Pardon me?
Motion to approve.
Thank you. Mr. Fetter. Mr. Alden.
Sir.
I'm looking for a second.
Sure.
Thank you.
Second.
Or myself, one of the two, but I prefer you. Thank you, sir. The minutes for the March 4 meeting are approved with a vote of 3-0, one abstain due to absence. Does anyone on staff have anything that they need to bring before the BZA at this time? Ms. Harden, Ms. Williams.
No, sir. At this time, you can continue on with your agenda.
Hearing nothing, then we will move forward. And at this time, I would take this opportunity to introduce Ms. Jenny Merck-DuPont, County Attorney. And Madam Attorney, the floor is yours.
Thank you. Mr. Chairman and members of the Board of Zoning Appeals, we're here this evening to talk about rules of procedure, but also some other things. Kind of what I want to go over with you tonight is your role, how things look from here. Once you do your thing here, where does it go? If it gets appealed further up to circuit court, talk about how that looks, and also just go through some general things that you have in your rules of procedure that you have currently. I know you're working to amend those, but you have some current rules, as well as some of the things in Robert's Rules of Procedure that apply to you as well. So as Chairman Deese stated, my name is Jenny Merck-DuPont. I am the county attorney. And I wanted to start tonight to talk to you about the role of the county attorney. So the responsibilities of the county attorney are diverse, and they include matters such as advising county officials on the application of various county ordinances, state and federal laws. We serve as parliamentarian. We draft legislation, ordinances, and resolutions. We provide legal advice and representation to the county government on a wide range of legal issues, including contracts, employment law, civil rights, environmental law, and land use, just to name a few. I keep hitting twice. Drafting, reviewing, and negotiating contracts, agreements, and other legal documents on behalf of the county government. We defend the county government in court, administrative proceedings, and other legal disputes. We advise county officials, departments, and staff on legal and policy matters and represent the county in legal negotiations. Let's see. Uh-oh. I may have lost it, Jennifer. Okay. Providing training and guidance to county officials, departments, and staff on legal and ethical issues. Keeping informed of changes in the law and developments in legal practice that affect county government. And we oversee cases or other matters and issues handled by outside attorneys. So we are a one-stop shop inside the county government, a law office inside the county government. In this county, there is only one of us, and it is me. So I am a true one-stop shop. So what can the county attorney do for the Board of Zoning Appeals? The county attorney can assume the role of another person's staff to the board, much like you have the planning director, you have a member of the department that sits as your secretary. With the county attorney's role to address only procedural issues. For example, what to do if a motion should end in a tie, as just an example. The zoning or planning officials should answer all operational questions about what the zoning code requires and do the staff work on the merits of any given case. The board may or may not want a staff recommendation. If so, that recommendation comes from the planning or zoning officials, not the lawyer. For example, whether or not a variance or special exception meets criteria is something for the zoning or planning staff to address, not the lawyer. The county attorney cannot advise the board and simultaneously advise planning or zoning staff on specific cases as the county attorney does on a day-to-day basis. Given the quasi-judicial nature of your proceedings, the county attorney cannot simultaneously represent the fact finder, which is you, and one of the parties, even if they are not named. And once a case starts, the county attorney takes on a general officer of the court orientation toward keeping the case on track procedurally. The county attorney, because they represent the planning and zoning staff on a day-to-day basis, cannot represent the board and provide the board legal advice on matters before it, because we are not impartial, because we work with the planning and zoning staff on a day-to-day basis on the very cases that come before you. So let's talk about some applicable rules and provisions for the Board of Zoning Appeals. The Lancaster County Board of Zoning Appeals is governed by a number of applicable rules of procedure. The South Carolina Comprehensive Planning Act provides for the BZA to adopt rules of organizational procedure. The BZA is additionally governed by procedural provisions which may be included in the Lancaster County Unified Development Ordinance, as well as the Lancaster County Codes of Ordinances. Where the BZA's own rules of organizational procedure and the Unified Development Ordinance and the Lancaster County Code of Ordinances do not apply, your rules of procedure, say Robert's Rules of Order, fills in the gaps. This is different from other boards and commissions because there is a county ordinance that says county council's rules of procedure fill in the gaps. Your current rules do not say that. They say if your rules do not apply, Robert's Rules fills in. The BZA is additionally governed by a number of applicable provisions which address essentially the structure and organization of the board. The South Carolina Comprehensive Planning Act provides for the membership and organization of the Board of Zoning Appeals. The Board of Zoning Appeals is additionally governed by structure and organization provisions included in the Unified Development Ordinance, as well as the Lancaster County Code of Ordinances. And where the South Carolina Planning Act and Lancaster County Unified Development Ordinance and other Lancaster County Code of Ordinance provisions do not address structure and organization, the General Provisions Ordinance, which was adopted by County Council in the fall of 2024, would apply. South Carolina Comprehensive Planning Act provides for the number of members, that's 3 to 9, that's state law. It also states no dual office holding will happen. There should be an election of a chairman who shall serve for 1 year or until re-elected or the successor is elected and qualified. It provides for an appointment of a secretary who may be an officer of the county or the board. Meetings are at the call of the chairman or other times as determined by the board. There must be public notice of meetings. Conspicuous notice must be posted on property or adjacent to property affected by hearings. There is an administration of oaths. There's the power to compel attendance of witnesses by subpoena. There's the keeping of minutes showing the vote of each member on each question. and the keeping of records of examination or other official action. That is all required under the South Carolina Comprehensive Planning Act. The Lancaster County Code of Ordinances and the Unified Development Ordinance provides for the actual number of members you have on this board, and that is 5. It also lays out the powers of this board. It also states that members represent areas of the county and others they have background and or experience in development-related professions on the board. You have 4-year terms with 2 consecutive terms allowed, and an additional beyond that would need a 2/3 vote of county council to stay on. There's staggered membership. Your officers are elected in accordance with your adopted rules of procedures. You all have equal rights, privileges, and duties, and the standards of review by the board are laid out in the Code of Ordinances and the UDO. And as I stated in the prior slide, Lancaster County recently adopted general provisions which fill gaps in organizational matters, not your rules of procedure. Those things that were adopted by County Council dealt with general powers and duties, residency requirements, the length of terms, as I mentioned before. If you stay on beyond 2 consecutive, it takes a 2/3 vote of council. There are some attendance rules, conduct rules, service and removal rules, training requirements, things that are to be filed with the clerk to council, and disestablishment. Those are all general provisions that fill in the gaps for all boards and commissions where ordinances or your own rules of procedure do not speak to it. And those your staff liaisons can go over with you and have available. So your current rules of procedure. The South Carolina Comprehensive Planning Act provides that you shall adopt your own rules of procedure. The Lancaster County UDO provides additional provisions which could be considered rules of procedure that are included therein. At present, the Board of Zoning Appeals has adopted a set of rules of procedure, which include the following. It lays out your officers, a chairperson, a vice chairperson, and a secretary. Your secretary right now is probably next to the chairperson, and no offense to your vice chair, the most important person that you have, because that person, the secretary, provides and publishes all required notice of meetings and hearings, ensures signage for a property is posted, prepares the agendas and meeting scripts, swears in participants and witnesses, collects your relevant evidence presented during meetings and hearings, keeps the minutes, serves written board decisions to all affected parties, transmits meeting minutes, and attends to the board correspondence. So obviously, as a quasi-judicial entity, you are issuing rulings. This person is in charge of making sure those rulings are done and get out. So next to the chairperson, probably the most important person dealing with your matters. Your rules also talk about meetings, the time and place, what constitutes a quorum, your rules of order that fill in the gaps as Robert's rules, what happens and how you cancel a hearing, and requires that your meetings and your hearings are open to the public. It also lays out application pre-hearing procedures. It provides a form, how those are calendared and docketed, the time of the hearings or when they will be had in accordance to days after filing, how an application may be withdrawn, how continuance or deferrals take place, and notice. And again, these are things that you all are looking at to potentially amend, so we're going over what you have currently. Your rules also talk about hearing procedures, appearances and who may appear before you, equal consideration being given to both sides, witnesses, cross-examinations are not allowed, evidence allowed which is not hearsay or cumulative, the conduct of the hearing, how you vote and the disposition of a matter, how you adjourn a matter, the form of your orders, the service of your orders, how appeals can be taken to circuit court, and how matters can be reheard. The next part talks about conduct and communications. The conduct is avoidance of situations, communications, and circumstances which lead to bias or prejudice. Later on in this presentation, I'll explain that a little bit better to you. It also talks about contact, that applicants or other parties should not be in contact. You should not be in contact with applicants or other parties, and that should be reported to the chair if that occurs. And again, I'll discuss that a little more in detail as we move forward. It lays out your records. There must be minutes, orders, and documents. Talks about how you amend and adopt your rules. The rules you're currently operating under were adopted on June 8th, 2017, and you amend them at any regular or special meeting by a majority vote of the members of the board. And then it lays out and provides you a script for your meeting. And as I've stated a couple of times, amendments to the above rules are being proposed, which my review has indicated that there is the inclusion of items such as agendas and voting requirements, which are not currently in those rules, but other amendments are being proposed within your existing rules of procedure. So it's not a complete overhaul per se, it's just an update and adding a couple of new sections to it that you haven't seen before. All right, if the Board of Zoning Appeals rules of procedure do not address a matter that arises during the course and scope of a meeting, as I've stated, Robert's Rules of Procedure fills in. So the following are some potentially relevant rules from Robert's Rules of Procedure which could be utilized to conduct the business of the board. And before I get into those, I just want you to see, this is Robert's Rules of Procedure. And this is not large print. This is very small print, very large book. They have books that are in brief. They also have books that are called for dummies. So those all exist. I am going to provide to you, and I'll leave it, and Ms. Williams or someone can get it to you. And some of you probably already know this. This is a guide on parliamentary procedure. It's about 4 pages long. This is another handout that goes through some things with Robert's Rules. I have for you some simplified charts of procedure motions. Another chart that has it a little bit more laid out than the one before, what they call a cheat sheet. And then even how you amend motions. If you've ever watched a council meeting, that's one of our least favorite things to do, is try to amend an amendment to an amendment. It is not fun whatsoever. But I will leave that with staff and they can provide those to you because those are very detailed and they provide a lot of Robert's Rules things that are very common for boards and commissions to utilize. But it pares it down from this very, very large book. So back to the presentation. Some of the things which might be relevant rules: procedural motions. Those can occur during the course of debate. Those are known as privileged, subsidiary, incidental, and recall. And don't worry, I'm going to talk about those next. Privileged motions do not require seconds. Those are things like adjourning, receding a meeting, raising a question of privilege, convening an executive session, or following an agenda. Those are privileged motions and do not require seconds. Subsidiary motions are applied to pending motions, much like I just said, an amendment is one of those things. Those are things like laying on the table, calling for a question, limit or extending debate, postponing to a time postponing to a time certain, committing something to a committee, or as I stated, amendments. Then you have incidental motions. Those are points of order, appealing the rule of the chair, suspending the rules, dividing a question, considering by section or paragraph as opposed to a whole, and requests and inquiries. And again, these sheets that I have together here that they're getting ready for you, that goes into those in much more detail, shows you what kind of vote it takes, how you make those motions, etc. And then we have recall motions. Those are motions that bring a matter back before the board. And that is usually to reconsider or to recall from the table or a committee. Okay, so again, Ms. Williams is over here putting together these cheat sheets, so you'll have those, so you will see that in a little more detail. With you all, I don't know that a lot of Robert's Rules applies because you have really motions and votes per se on factors. So it's not a lot of Robert's Rules, but those few things are things that could pop up. And again, they're laid out there, but they're laid out in these sheets as well. But again, I want to move forward and talk about some other things very specific to you because you are a quasi-judicial board. So you all deal with witnesses and exhibits. So some pointers when you're dealing with witnesses and exhibits. You need to look at if the questions and answers are sticking to the request because you are quasi-judicial. Think of yourself as the judge and the jury in these matters. So if you ever watch a law show or ever watch a trial or if you've ever been in trial, we talk about relevancy. Are those things relevant? Yes, sir.
What is the term request? What does that refer to, please?
It would be to the request before you. Is it the application? Is it a special exception? Is it a variance? What may it be in front of you?
Thank you for the clarification.
You're welcome. So again, is it relevant to the matter before you? Are the questions or answers relevant to the matter you are hearing? That is the relevancy. It needs to not be cumulative. In other words, tending to prove the same point over and over and over and over again is not necessary. And it cannot be hearsay, and that is testimony based on what a witness has heard from another person rather than on direct personal knowledge or experience. So in other words, if someone says so-and-so told so-and-so that they would not be at this meeting tonight, that is hearsay. But if it is so-and-so told me directly they would not be at this meeting this evening, that's not hearsay because you are a party to that conversation and you can be questioned on that. Hearsay is something that the parties to that conversation cannot be questioned about because they are not present. Yes, sir.
Going back to non-accumulative. Witnesses speaking to the same point over and over again who have signed up and it's all legitimate that way. What is the process for saying, okay, wait a minute, gang, wait a minute, witnesses, how do we deal with that so that we're not listening to the same thing?
So remember, the chair is in charge of this. So the chair would be able to once something continues to be tending to prove the same point over and over again, he may sit them down and tell them, thank you very much for your testimony. We've already received this. We'll note it for the record.
So we kick Charles underneath the dais.
You certainly can. Also, you want to look at the purpose of questions. Let me see if I can get there we go. Are we addressing the criteria for special exceptions or a variance? Make sure that the questions are actually addressing what you have before you. Is it a special exception or a variance? And then the value of discussion and the openness of debate. It is different here for you all from a jury and a judge because your deliberations are done in open session. I know that there's a lot of angst with that, but unfortunately that is the law. So there is a value in discussion and the openness of debate here. So if questions need to be asked, discussion needs to be had, debate needs to be had, that is a good thing because you can talk about openly witness testimony, exhibits, and evidence that has been presented to you to make a clean, clear record. So some pointers to avoid bias or prejudice. As I mentioned before, there are some rules in your current rules that talk about communications with other parties. So that is known as ex parte communications. There can be no ex parte communications. What that means is communications between a party and the body, which is you all, the board, when the opposing party is not present. So if you are having conversations or communicating with an applicant, their representative, their witnesses, without the planning or zoning staff in attendance, that is improper. Or vice versa. If you are discussing with the planning or zoning staff a matter before you are requesting information on it without the other side present, that is improper. That is an ex parte communication, and that can cause problems and overturn rulings on appeal. Yes, sir.
Specifically, please, does this mean that I cannot call up Allison as an example and say, Allison, I need to have this additional information?
You cannot do that, no, sir.
So if that's a necessity on my part, what's the specific process that I need to follow?
Well, there's two problems with that. One is the ex parte communications. The second is FOIA issues. You can talk to the chairman about the things that you need, and the chairman can discuss with staff within bounds of not talking about specific hearings, but specifically talking about information that the board may need that is not being presented. For example, if it is staff recommendations, if it is reports, et cetera, he can talk in general terms to the staff about what is necessary for hearings.
Okay, and specifically then, looking at these changes. Want to bear down here because I struggle with following the legal implications. Looking at this, does that mean that I'm not able to communicate with staff saying, what did you mean by this?
That's exactly what it means. You cannot ask staff about specific things regarding any hearing in front of you without the other side present.
I might actually understand that.
Ms. Merrick DuPont, if I may also add in that if you're talking about the rules of procedure, that's different than if you're talking about a case. When the rules about ex parte are about when we have a case coming before you. If you have a variance coming before you and you want to know certain information about the case, you have to wait till you get here to the meeting to talk to staff directly or the applicant directly during the question and answer period.
Can you speak to that then? I got a contradiction here.
I can. So if I can, let me give you two things that have come out of cases as well as the Attorney General. This might help a little bit. So this is a statement from the Attorney General. In view of the quasi-judicial nature of service on the Board of Zoning Appeals, board members shall, the word shall, it's not may or should, it is shall not, discuss any case pending before the board with parties of record or other interested persons, except as part of a public hearing concerning that case. If a member is contacted by a party of record or other interested person, the member shall decline to discuss the case and inform the contacting person of the opportunity to appear before the board at a public hearing to present his or her views on the record. And if you'll give me one more second, I'll read you one more thing, and then I can address your question, Mr. Alden. If contact or relationship between an interested party and a member is such that it compromises or appears to compromise the ability of the member or the board to render a fair and unbiased decision in a case, it shall be the duty of the member to disclose the contact on the record at the start of the meeting where the case is to be heard and to recuse himself or herself from participation in the discussion and any vote concerning the case when the contact or relationship exists. So, Mr. Alden, if we go back to the first part, the Attorney General is saying there exactly what Director Harden just stated. If you have a question regarding generalities regarding the BZA, service, the rules of procedure, your organizational procedure or rules, those things you may directly speak with staff about outside of the presence of another party. If you have a question about the hearing or matters pertaining to the hearing, it has to be with both parties. The second part is talking about if that happens to you and you feel like someone has approached you and talked your ear off and you could not get them to stop, and they are talking to you, they're an applicant, and they are talking to you about the matter before you, and you now have a lot of information that you would not have otherwise had until the hearing. If you feel that it has made an impact upon you, then this is stating that you should disclose that and potentially recuse yourself from the hearing to ensure that there is a fair hearing had, because you may now be prejudiced and biased. So that's some pointers on avoiding bias or prejudice. Just don't talk to the other parties if they try to approach you, and they probably will.
Thank you for clarifying that.
You're welcome. So the use of an executive session, that is mandated by South Carolina Code Annotated 3470, better known as the FOIA laws here in South Carolina. A public body may hold a meeting closed to the public for one or more of the following reasons. There are several of them. It includes discussion of negotiations incident to propose contractual arrangements and proposed sale or purchase of property. The receipt of legal advice, you will see I have highlighted that, where the legal advice relates to a pending, threatened, or potential claim or other matters covered by attorney-client privilege. The settlement of legal claims or the position of the public agency in other adversary situations involving the assertion against the agency of a claim. The receipt of legal advice is going to be where you all could go into executive session, and we'll discuss that a little bit more here. Before going into the executive session, though, the public agency or board shall vote in public on the question, and when the vote is favorable, the presiding officer shall announce the specific purpose of the executive session. No action can be taken in an executive session except to adjourn or return to the public session. And again, this is not just for you all, this is specific to all public bodies, so county council, municipal councils, school districts, special purpose districts, all of them. And the members of a public body may not commit the public body to a course of action by polling of members in the executive session. So that's just the generalities on executive session. Now, when can the board hold an executive session? Whenever my clicker will work, that's when we can hold one. When an executive session is noticed on your agenda, you can have an executive session. When one is not noticed on the agenda but is requested and approved via a 2/3 vote of the board, and that is by South Carolina FOIA. That has nothing to do with any rules of procedure. You can have one provided no, quote, final action is taken coming out of executive session. Now, you all would be in executive sessions for a specific reason, so you more than likely are not going to come out and take any action other than potentially receive legal advice regarding a hearing you are in or a matter you are hearing, and you are going to come out and take final action, but that is already noticed on your agenda. So there would be no violation here if you needed one on the fly, per se, that was not noticed on your agenda. So for what purpose? For purposes of a quasi-judicial entity, for the receipt of legal advice requiring a specific legal issue or concept related to the matter before the board. That's what the legal advice would be. So, what is the legal advice versus a substantive decision? There is a difference. Legal advice can be provided to the board regarding a specific legal issue or concept related to the matter before the board, but cannot be provided as to how that legal issue, relevant law, criteria, etc., should be or can be applied to the matter before the board. That is the difference between the legal advice and the substantive decision. So you cannot retreat to executive session to discuss how the law, criteria, law, whatever, applies to the matter before you. As we stated, you must deliberate, debate, and discuss in open session as well as rule. But if you have a matter of law that is novel, for example, we have had one in the past where we had the Religious Institute Land Protection Use, RLUIPA is all I know, that was novel and unique and not something that constantly comes up. So legal advice regarding what that is was provided. However, the attorney could not advise how to apply it to the matter because that is the purview of what the quasi-judicial entity needs to do. That is what a judge or jury would do without a lawyer telling them how to do it. Yes, lawyers argue how they want them to do it, but they do not tell them how to do it. So legal advice cannot be provided to the board as to how to rule on the matter before it. And again, you cannot use executive session to avoid a public discussion or deliberation. It is required. It is not allowed in an executive session and is not specifically allowed by your statutes. There are some other, the Board of Assessment Appeals does allow that, but unfortunately the Board of Zoning Appeals, the General Assembly did not write that into your statutes. And then again, as we stated, no action can be taken in executive session. No votes, no polling, no motions. So again, no polling. All right, so we've had a lot of questions about what happens once you all rule on something. So the South Carolina Code 629.790, the Comprehensive Planning Act, talks about how you appeal from this board. A person who may have a substantial interest in any decision of the Board of Appeals or an officer or agent of the appropriate governing authority, so either the applicants or the county, may appeal from a decision of the board to the circuit court in and for the county by filing with the clerk of the court a petition in writing setting forth plainly, fully, and distinctly why the decision is contrary to the law. And that appeal must be filed within 30 days after the decision of the board is mailed. So if you hearken back to what I said in the beginning, secretary is very important because that's who sends out that order from which they can appeal from. An appeal from the board, from the BZA, would be handled by an attorney either retained by the county or provided under the Lancaster County Errors and Omissions Policy coverage provided by the county's insurer, the South Carolina Association of Counties, depending upon the claims asserted on appeal. We do have an errors and omissions policy, which does cover things like these kind of rulings to an extent. If that coverage does not apply, the county would retain an attorney, whether it be me or someone else. There would be an attorney. Claims for individual or personal liability for any decision rendered by board members themselves would be argued against and requested to be dismissed, provided a board member was acting in their official capacity. Official capacity claims against a board member would be handled by an attorney, either retained by the county or provided under Lancaster County Errors and Omissions Policy coverage. Only in the instance where a board member is personally sued and not sued in their official capacity due to actions outside the scope of their appointed duties as a board member would the county not provide legal representation. So in other words, as a board as a whole, as you as a member of the board, you are covered by the county and by our errors and omissions policy. So unless you act outside the scope of your duties as a board member, you are covered. Now, there is a thing called pre-litigation mediation in the BZA statutes in the South Carolina Code 629-825, and I want to go over that with you. A property owner can file an appeal with a request for pre-litigation mediation, and if they do that, that request must be granted. Now, this is by the circuit court, not by you all. This is by the circuit court. But I want you to know exactly where things go from you. Notice of the opportunity to attend mediation must be provided to the property owner or the representative, any other person claiming an ownership interest, or a person who the court grants leave to intervene in a matter. If the mediation is successful, a written mediation agreement must be provided within 5 working days. They work this very fast. Before the mediation settlement takes effect, it must be approved by the local governing body in a public session, and it must be approved by the circuit court. So mediation, while you can do it, and it sounds like a great thing, you have a 2-step process to get, well, 3-step. You have to agree with the other party, the governing body has to agree, and the circuit court has to agree. Oops, sorry. Any land use or change that is agreed to in a mediation which affects existing law is only effective to the real property subject to the mediation, and the settlement sets no precedent. So it doesn't change anything with the law, or really, it's only changing your ruling because it's only specific to that one thing. If the mediation is not successful or a settlement agreement is not approved by the local governing body, the property owner may appeal by filing a petition with the circuit court within 30 days of the report of no agreement or the failure to approve the settlement by the local governing body. 2 bites at the apple here. So they can do mediation, and then if they're unsuccessful, they can then file a lawsuit in circuit court. The circuit court must approve a settlement if it has a rational basis to do so. If a settlement is not approved by the court, the judge schedules a hearing for the parties to present evidence and then would issue a written opinion, just like a regular court case. And then a party may appeal from that circuit court decision in the same manner as other appeals of judgment from the circuit court. That would be to the Court of Appeals and on up. And usually it pretty much dies at the Court of Appeals. So that's pre-litigation mediation. If someone straight up appeals your board decision, upon 10 days' notice to the parties, a presiding judge of the circuit court of the county must proceed to hear the appeal on a certified record of the board proceedings. Again, I'm going to hearken back to your secretary and the need for very detailed meeting minutes, transcripts, orders. Thus the need for open debate and discussion so that it is all on the record, because what the judge is looking at is the record of the board proceedings in order to make a decision. The court does not take additional evidence. Again, very important that good discussion, debate, and deliberations takes place and is on your transcript. In the event the judge determines that the certified record is insufficient, they may send it back to you for another hearing. Not something you want to do is rehash a whole matter because somebody's appealing what you did in the first place. Well, there we go. The court must determine only whether the decision of the board is correct as a matter of law. That's it. They look at the UDO and they will decide from that point. In the event that the decision of the board is reversed by the court, the board is charged with costs, and the costs must be paid by the governing authority which establishes the board. So that's the county. That's not this board. That is the county. And nothing prohibits a property owner from subsequently electing to assert a pre-existing right to a trial by jury of any issue that's beyond the subject matter jurisdiction of the board, such as, but not limited to, a determination of the amount of damages due for an unconstitutional taking. So in other words, they are not going to be taking this to circuit court against the Board of Zoning Appeals to say that there was an unconstitutional taking of their property because you did not grant a variance. That would be a separate lawsuit. That would be against the county, not against the Board of Zoning Appeals. It is only your rulings that are appealed. And I want to put in here what you have a power of contempt against, not against you, that you can take against people for not being proper with your proceedings. It is in the South Carolina Code, in the same Comprehensive Planning Act, and it says, in case of contempt by a party, witness, or other person before the Board of Appeals, the board may certify this fact to a circuit court of the county in which the contempt occurs, and the judge of the court in open court or in chambers after a hearing may impose a penalty as authorized by law. So if you feel that someone is in contempt of this board, we can proceed with a matter in front of the circuit court to bring someone before the circuit court charged with contempt and penalized as authorized by law. And there again, that is more than likely something that your county attorney would do because that's a procedural matter as opposed to something that really has to do with the law before you. Yep. Okay.
Hey, a rule is a rule. And let's face it, without rules, there's chaos.
So I thought I'd just give you a funny. Without rules, there's chaos. All right, so and I lost my last one there. So that was just a quick and dirty, and I apologize if it was a little too long or too much, but I wanted to give you pretty much kind of an overview of everything that really applies to you in regards to organizational rules, rules of procedure. So I'm now open to take any questions from you that you may have. We've had some as we moved along the way, but glad to take any right now as well and try to help you answer them. Did I do that good? Mr. Alden, I did that good?
I'm not going to concede anything tonight.
Okay, I got you. I
wanted to back up to your comment. As usual, my paranoia plays
Yeah, sure.
well in terms of legal
Sure.
exposure. My notes are shaky at best here.
Okay.
You're talking about roles
Sure.
that you would play as county attorney.
Mm-hmm.
And at some point, in the middle of a conflict of interest, perhaps is the right term,
Okay.
that you would not be able to represent the board because of your legal responsibilities representing the county.
Correct.
Where does that leave the board in that set of circumstances? And I would welcome you to revisit your presentation on that point.
Okay. I think I can make it clear without having to do anything here. So in terms of you all conducting a hearing, Before you, you will have the planning or zoning department, which I work with on a day-to-day basis. So if they have a variance in front of you, it is very possible that I, in my role daily as the county attorney, that Ms. Williams or Ms. Harden have discussed the matter with me and gotten my legal opinion. So therefore, what their position is regarding that matter could involve my legal advice to them and my legal opinions. The other party, obviously, would be an applicant or so forth. I would not have anything to do with them. As this board, you are a neutral third party, the trier of fact and law. If I am sitting here providing you legal advice as to any of the law, the criteria, or the things that have to do with the hearing in front of you, the criteria or the law, then that I am not a neutral, unbiased party, because I have already explained to one party how the law, the criteria, or the legal issues fit. Okay, but I can help you procedurally. In other words, the rules of procedure, how you conduct a hearing, how you proceed with the hearing. I can do that for you in my role of the county attorney, because that has nothing to do with the positions of either party coming before you. But the position of the county is more than likely going to have my legal opinion behind it. So up here, if you are asking me questions about criteria or the hearing matter, my opinion is biased because I've given them what my opinion is, and I'm going to lead you to that side because that's where my legal opinion lies. So I cannot sit here and provide you any advice. As a matter of fact, no attorney can provide you advice as to how criteria or the substantive law applies to the matters in front of you. They can only provide you advice on very specific legal issues that may be a part of the hearing. As I mentioned in the past, we had the RLUIPA, and we did have an attorney who came in and spoke about exactly what that was, what the factors were with it, what the criteria was, what the elements were. But he could not assist this board in determining how to apply it to the hearing and the matter in front of them, because that is the job of the board as that quasi-judicial entity.
And because of this, we put into the request for the budget this year additional funds to specifically hire the BZA, their own attorney, for meeting attendance and the like. And we hope to have enough to do that at the end of the budget process.
Thank you for rehash.
You're welcome. You're welcome.
Anyone else?
I got a question concerning the appeals process.
Sure.
It has to do with, what is that bar that establishes a person who has substantial interest, and so that they would be able to appeal?
So they would have to file what we call a motion to intervene, and the judge has to look at that and see. I mean, it would be very fact-based upon what they say their reason is. I can't even give you what that would be. It may be an adjacent property owner who, if you, let's say you grant a variance and somebody's got this variance now that encroaches upon their property or something with their property, moves something closer to them, then obviously they might want to intervene, and they would file a motion to intervene and say, this board allowed this and it's doing this now to my property, or has taken away value, or whatever that might be. A judge would review that and then determine, more than likely, yeah, they have a substantial interest in how this matter turns out and allow them to intervene. Now, if it's just Joe Smith who lives in the county who says, well, I don't like the fact that the BZA did that on that piece of property in the Panhandle and I live down in the lower part of the county, more than likely the judge is going to say, I'm sorry, these rulings only affect this one piece of property. It doesn't set precedent. It doesn't set the law on this. So therefore, you really don't have a substantial interest in how this plays out. So it's really fact by fact, case by case basis, and really circumstantially based on what a judge would review and what they would submit, how much they submit.
If I may offer a couple examples from my previous employment, we have had people appeal decisions based on the concept of a view corridor to the ocean. This person lived on the third row, which means they were 2 streets back from the ocean, and were appealing a tower being built because it would take away their view to the ocean. We did not have a regulation that protected that view corridor that they had under the code, and so that was somebody that was determined not to have a substantial interest. When I worked in the western North Carolina mountains, there were view corridor policies because of the mountain views and the like, and constructing a home in front of someone else, from someone else's home that elevates that home and blocks the view of the other person was prohibited. You had height restrictions based on topography and the like. That person would have had and correct me if I'm wrong, but that person under the law, since their view was being impacted by the construction, they would have been a person that was directly impacted by that. And it would be one of the codes that you can put a finger on. We've had people talk about the difference between being a neighbor, an adjacent property owner, and being down the street. Down the street also believes that they are impacted, but direct impacts often are more directly related to the adjacent property owners.
Anyone else? Thank you.
Welcome. Thank y'all. I hope it was, and we will have the PowerPoint, and I'll make that available to the staff so that they can provide that to you, as well as those handouts. So you'll have those as well. You're welcome. You're welcome.
We will go to between you and the young lady sitting beside you over there. My understanding is that there are rules and procedures set aside by the Board of Zoning Appeals that are basically in conflict with some of the other rules that are in place, like some of the ones that the council has been looking at and approving. There's one in particular that I want an opinion on of some type. You can say yeah or no, I don't care. But there's one in there that allows, as long as there's a quorum available, it allows people to vote on telephone. I disagree with that 100%. And I think in our own rules, it states that you have to be present in the meeting to vote. So I want to make sure that that is maintained.
I can help you right now. So by statute, you are required to adopt your own rules of procedure. You have those currently. You have some that you are working on amendments to right now. Council's rules of procedure, which you're talking about, that has the electronic voting and participation, those are to apply to all boards and commissions apart from those that are required by law to adopt their own rules of procedure. So you all have your own rules of procedure. That's not in there. And you have a section in your rules of procedure currently, as well as I think in the amended version, that does not refer to council's rules of procedure stepping in any form. It says Robert's Rules fills in the gaps. So therefore, you are not subject to those electronic voting meeting requirements included in council's rules. You are not subject currently, the way your rules are written or your amended rules are written, to those adopted council rules whatsoever.
This makes it simpler. Thank you so much. Anyone else? Does staff have anything further they want to go? Ms. Harden? Ms.
I can say there is one case that has been submitted for the June meeting, so we will have a hearing in June.
And I hope that we continue to have meetings every month. We fell into a groove, and I say we, I was not a member of the BZA at the time. But we fell into a groove to where meetings were not being held when they really should have been because people didn't show up. And I think people actually got into that, well, we didn't have a meeting last month, we didn't have a meeting this month, and not even think about it next month, you know. And then they don't show up and there is calls for a full meeting and the votes. And people have a tendency to do what they normally do on a daily basis. I get up and put my shoes on every morning. If there's a meeting on the first Tuesday of every month, I'm gonna be there at 6 o'clock or before. If I don't do that, I get that tendency not to do it, you know. And believe me, there are mornings when I get up and don't put my shoes on, but I have a reason for it. But I would like to see this board meet, if for no other reason, than to make a sheet of minutes every month. Yes, ma'am.
Yes, Mr. Chair, and the rest of the board, Chairman Dees and I did have that conversation last month, and what we kind of settled on is if there are no active cases for a month, we still plan to have a meeting, and I will try to arrange for a training session, either with Ms. Merck DuPont or some other type of training, and if I know ahead of time, I can work to try to get those certified to get you some of your continuing education credits. So just plan to be here every month unless something really crazy happens. I will have to check on the July meeting because our July meeting, I have to check on the calendar because I believe we may have canceled that one last year when we had to send in the dates for council to approve because it's the week of July 4th. But I will verify that and someone will email you all tomorrow for that.
And Mr. Chairman, if I may add to that, in order to get your orders finalized, you need to have your minutes approved because that's where you have made your votes and your decisions. So it is very important because of those 30-day deadlines that you all do meet at least to approve minutes as you did tonight. And then as Ms. Williams said, perhaps have some level of training or something like that so you're not wasting your time just to come up here to do one thing. But and I understand you don't like the electronic meetings, but that was one thing that council did talk about with electronic meetings. If there's something like minutes that need to be approved instead of convening everyone physically. But I believe it sounds like your staff is looking to do the physical convening and then provide you something beneficial along with it.
This would give not only this board an opportunity, but even some of the other people in the building, if we can manage to arrange credit meetings where we're getting that 3 hours a year in, even if we do it an hour at a time, you know, that's better than spending the day up here or going to Columbia or to Greenville or somewhere to get 3 hours in.
I think that's an admirable effort. And I would
3 hours,
encourage that.
3 hours are required every year by all of us. And, you know, if we can, if for no other reason, we can come and sit down and enjoy each other's company for a few minutes.
And have dinner.
And Miss Jennifer and these other people. I mean, you know, it's not like it's an open and shut case. You know, we've got interesting topics that come up monthly. So, my business. And if there is there is no need for a motion for that because the chairman can call a meeting. And I'm calling one every month. And more if we need them. All right.
We do need movement to adjourn.
Do we have a meeting? Do we have an adjournment? Let me see. Do we have a motion to adjourn?
Motion to adjourn?
We got it. And the second, we are adjourned. That's something we don't really have to vote on. No. But thank all of you.